It's not the definition that economists have traditionally relied on. On the definition of recession, which has been an issue that I know many of you have reported on, as Secretary Yellen said on Sunday, 2 negative quarters of GDP growth is not the technical definition of recession. It's not the definition that economists have traditionally relied.
Let me pull a little Billy Madison and say, oh, really, fool? Really? 2 consecutive quarters is not the definition of a recession. It's not the definition that economists have generally relied on. Oh, really? This is from, I recognize it's from Investopedia. Take it for what it's worth. But spoiler alert, all definitions are roughly the same. He's right. It's not a technically written in stone definition. It's just the economic principle of what the definition typically is. And let me read from Investopedia. What is a recession? Well, at the very least, they're not asking what is a she-session. I'm going to pull that clip up in a second. Oh, seems that I've been taken out of my own stream. Okay, hold on. I'm in a hotel room, and my daughter just pulled on the cable and pulled out. Oh no, it's good. No, I have to fix camera now. Hold on, setting. Let me see if I can get back to the. Forget it. We're going with the camera. We're going with the camera on the thing. Forget it. We'll do it live, people. Oh, what's going on now? Now I see her photos uploading again. No, people, I'm sorry. We're gonna have to go with the crappy built-in Mac camera. Where was I? Oh, yes, I was reading the definition of recession. What is a recession? And I don't know if you heard my joke. At least they're not asking what is a she-session. Because in addition to the political left changing the definitions of words, recession no longer means 2 consecutive quarters of negative growth. They also make up their own words, such as she-session. You know what? Parentheses, we're going to open that in a second. From Investopedia. What is a recession? A recession is a significant, widespread, and prolonged downturn in economic activity. Because recessions often last 6 months or more, a popular rule of thumb, that's a politically incorrect analogy, Investopedia, is that 2 consecutive quarters of decline in a country's gross domestic product, GDP, constitutes a recession. But don't believe them. Don't believe your lying ears. Let's go to Forbes. What is a recession? A recession is a significant decline in economic activity that lasts for months, even years. Experts declare a recession when a nation's economy experiences negative domestic growth, rising levels of unemployment, failing retails, yada, 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 over an extended period of time. Recessions are considered an unavoidable part of a business cycle. Let's see, does this one, official recession. Let's just see 2. Let's just see if the word 2. In 1974, economist Julius Shiskin came up with a few rules of thumb. What's wrong with these people using this analogy? This expression can get people canceled these days. To define a recession, the most popular was 2 consecutive quarters of declining GDP. A healthy economy expands over time, so 2 quarters in a row of contracting output suggests there are serious underlying problems, according to Shiskin. What did the guy just say? Oh, there's no definition. It's economists don't agree on a definition. They don't agree on a definition until you don't like the definition anymore. You pathological, your phone is triggering. You pathological, deceitful, word-changing, word-fabricating liars. Liars. There's no other word for it. Liars. There's no standard definition except for the one we've been living with since 74, 84, 94, 2004, 2014. 48 years. 48 years, give or take. There's no widely accepted economic principle except for the one established by an economist in 1974, followed by economists ever since. The rule of thumb, by the way, let's get the etymology of this out for anybody who hasn't seen the movie Boondock Saints. First movie reference, people. Rule of thumb, etymology. Would it be rule of thumb origin? If anybody hasn't seen Boondock Saints, it's a good movie. But let's just see what the origins are of the term, the expression, rule of thumb. The Guardian, actually the phrase rule of thumb simply comes from a usage of the thumb as a unit of measurement. There was an old rumor that it's derived, here we go, we'll go to Wikipedia. Refers to the approximate method of doing something based on practical experience. Let's just see where the part about the stick is. A modern folk etymology, so I might have to stand to be corrected here, holds that the phrase is derived from the maximum width of a stick allowed for abusing one's spouse. Under English common law, this belief may have originated in a rumored statement by 18th century judge Sir Francis Bueller, that a man may beat his wife with a stick no wider than his thumb. The rumor produced numerous jokes and satirical cartoons at Bueller's expense, but there's no record that he ever made such a statement. Okay, I stand corrected. But the problem is, as we know from the OK symbol, once the rumor is that it means something, and it means that hitherto far going forward. Okay, people, so super short notice for this stream. I wasn't even sure I was going to be able to do it. We've been driving for the better part of the day, and by the better part of the day, I mean 9 hours. The better part of our day spent driving with my daughter in the car was spent listening to the Tamara Lich court hearing on the bail rehearing. And it's an infuriating thing to listen to. Infuriating. First of all, technically, because I was losing reception oftentimes, and it was bugging in and out of the Zoom call, but more so because of the substance of the absolute sham of a prosecution, political prosecution, and it is overt persecution. When Tamara Lich shows up in court in shackles, Pete, in shackles. I wasn't watching it because I was listening to it while driving, and at the end of the hearing, the judge said, "And please remove those shackles from Miss Lich." It's a travesty. But at the very least, finally, another judge got it right. And in as much judicial smackdown as can legally and politely be done, stuck it to those justices of the peace who rendered horrendous decisions on the bail prior hearings. But hold on, before we get there, standard disclaimers. Hey, Viva, how do you feel that you moved to America just as it's about to go into civil war? I don't believe that. I know, Tim, well, first of all, it depends what you mean by civil war. A war, a social war, culture war. How do I feel? How do I feel about witnessing what's happening in Canada? Anyhow, thank you for the super chat. And Ginger Ninja says, justice delayed is justice denied. So glad that Tamara is released, but that is in no way a redemption of the Canadian justice system. Good to see you, Viva. It's even worse than that, by the way, because the terms of her release are kind of a little more onerous than they were the last time when Karimji and the full force of the prosecutorial justice system went after her like she's a terrorist. Okay, a couple more here. We're going to get this. Perhaps it should have been the rule of wrist. And Viva War Campaign has interviews of people being roughed up by Glenn McGregor news crew. Viva War Campaign has interviews of people being roughed up by Glenn McGregor CTV news crew. I'd be surprised to see that. I'll look for it. Hold on. So, by the way, standard disclaimers, everybody. YouTube takes 30% to super chats. If you don't like that, we are simultaneously streaming on Rumble. Rumble has a thing called Rumble Rants, where they take 20%. So better for the platform, better for the creator if you want to support. But the best way to support, without a doubt, without a doubt, is vivabarneslaw.locals.com. So it's going to be a short stream just because I have to be respectful and entertain my respectful too, and entertain my daughter while we're on the road. A long time in a car. It was a beautiful, beautiful drive, but it was a long one. I'm going to pull up an article that's just going to guide me. I was taking mental notes while driving, and then I took notes once we pulled over. Does everybody need the context of Tamara Lich? Do we need to go over very briefly how we got to where we're going? We had the protest. We had the occupation of Ottawa over the course of 3 weeks in the winter. I think it started on February 7, I want to say, they were arrested on February 18. So it was the month of February. I think it started late January. Truckers drove across the country, formed a convoy, parked on Capitol Hill, on Wellington Street, and 4 blocks going down, a few blocks going this. They parked there, and for about a solid week, honking their horns. It was like a culmination of abuse and release, where these people, Canadian citizens, the backbone of Canada, truckers, farmers, the people who produce what we consume, who ship what we consume, who have been beaten down and abused by Justin Trudeau's unscientific, unconstitutional, and inhumane policies. They said enough is enough. You're going to impose this vaccine mandate on truckers. We're going to drive to Ottawa, and we're going to stick it to you in the sense of creating a serious inconvenience for Canadians. Can't pretend it was not causing an inconvenience. A protest that doesn't cause something of an inconvenience, it's not a protest. A protest that doesn't make noise, it's not a protest. Now, the extent to which it can make noise, honking horns is one thing, breaking windows is another. Blocking streets is one thing, burning buildings is another. So this convoy, which at first, by the way, because I'm a noob wet behind the ears, I had no idea what was going on. People on my channel, the week or two before this even happened, says, Viva, why aren't you talking about the convoy? And I'm like, what convoy? And then I Google it, and then I see, there's a convoy going from one city I forget what the city was, in British Columbia to another city, protesting road conditions. Like, not to be disrespectful to that convoy, that's not exactly what people are telling me the convoy is. Then I find out that there's a convoy going from Vancouver to Ottawa, truckers driving and picking up steam as they go along. And then it becomes big enough that CBC and mainstream media in Canada has to recognize it, but they downplay it. Small convoy, no big deal, ignore. Then it gets too big to ignore and downplay. Then they have to demonize it. Racist, extremist, xenophobic, misogynist, anti-trans, radical, right-wing, selfish bastards coming to occupy Ottawa to overthrow the government. Literally, the media was saying they're coming to overthrow the government. And I was down at an event for Project Veritas. People are like, dude, you have to get down here. You have to see what's going on because it's not like what the media is saying. And I'm saying, I'm reading the media and I'm getting direct messaging from people on the ground. And I was like, second I got back, I got to go down and see it. I went down and live stream documented for 13, 14 days because I said, if there's Nazi flags and there's Confederate flags at a protest in Canada, I want to see it. And if it's there, you're going to see it live. So there was honking, and it was glorious in its deafening noise for 3 to say 5 days. They stopped honking, and then they just parked their trucks there, and it was the most peaceful, the most patriotic, the most invigorating, inspirational protest I've ever seen. For the first time in a long time, I was proud to be Canadian again. And I was just livid with the media because the media says they're desecrating the war memorial. They're desecrating the Terry Fox memorial. That desecration consisted of a Canadian flag in Terry Fox statue's hand. The desecration of the war memorial, bullcrap. Might have been a dog for all anybody knows. But one thing I know from having seen it firsthand, documenting it, that was under 24/7 surveillance by veterans. Shoveling snow, salting sidewalks, feeding the homeless. That's what this protest was. 3 weeks. Tamara Lich was one of the organizers, one of the main spokespeople for this protest. 3 weeks, this protest goes on. Trudeau doesn't have the courage, the decency to come talk to the protesters, ignores, demonizes, pretends to have COVID, flees the capital, goes into hiding in British Columbia. And then after 3 weeks of not listening, not discoursing, not negotiating, not acknowledging, he brings in a militarized police force, busts skulls, literally, pepper sprays, detonates stun grenades. I was within 5 feet of a concussive grenade that went off, and then arrests the protesters. Barber, I'm going to forget names, Tamara Lich, Pat King. And Pat King was kept in jail for 5 months. Tamara Lich was in jail for 2.5 weeks, initially denied bail on charges of mischief. Finally granted bail after 2.5 weeks under the most onerous conditions you can possibly imagine. Excessive beyond measure in my mind, but released nonetheless. At one point, she was awarded the George Jonas Freedom Award by the JCCF, who also happened to be her attorneys, relevant for the story. She makes a public statement that she's going to accept the award. The Crown tries to move to put her back in jail on the allegation that her public statement that she's going to accept the award is a breach of the terms of her release. They move to try to get her back in jail. Convicted sexual assaulters released on bail pending their appeal after conviction. Dude who ran over 4 people in Winnipeg, released. Tamara Lich, misdemeanor charges of mischief. Oh, they're hybrid. Sorry. Misdemeanor indictable offense, hybrid. Nonviolent. They move to put her back in jail. It's denied. It's at the hearing where it's denied. The judge who hears it says, there is nothing wrong with Tamara Lich publicly stating she's going to accept an award, and there's nothing wrong with her going to this award ceremony to accept the award. It's an award, the George Jonas Award for Freedom, a Hungarian individual who fled Hungary. She goes to the award show, accepts her award. In accepting the award, comes down, shakes the hand of one Tom Marazzo, an individual who she was prohibited from having direct or indirect communications with in the absence of counsel. She was sitting at his table at the awards show. The Crown moved to put her back in jail on the basis that she violated the terms of her bail. They issued a nationwide warrant for her arrest, arrested her in Medicine Hat, Alberta, had her in jail for 6 days before they came and got her, brought her back to Ottawa, had her in jail until today. And the hearing that they had before the Justice of the Peace as to whether or not she should remain in jail pending the hearing, the bail hearing, the Justice of the Peace said it was a flagrant, in-your-face, wanton disregard of the terms. Surely when the judge said you could go to the awards show, it wasn't to sit at the table of someone you were not allowed to talk to except in the presence of counsel. And she was locked up in jail. And then she she challenged the terms, or they had the bail hearing today, and a judge, not a Justice of the Peace, heard it. And in as much as the judge can politely smack down the Justice of the Peace who issued this order that she remain in jail, he smacked down this Justice of the Peace. Okay, that's the summary. So that's what happened today. And the hearing, Karimjee is not playing fair. I was listening to the hearing yesterday. Karimjee, I think he saw that it wasn't going his way as of yesterday. Karimjee is the prosecutor. Greenspan is the defense. Karimjee said that he didn't intend on adducing any new evidence, and then insists on cross-examining Tamara Lich on the bail hearing de novo, which occurred today, starting from scratch because the previous order was set aside. The previous detention was set aside. De novo bail hearing, Karimjee was pursuing on the basis, was it Karimjee pursuing it or was it the applicant? Either way, de novo from scratch, Karimjee says, I want to cross-examine Tamara Lich a third time, and the Surtee, I believe it's a third time as well, the Surtee publication ban on the Surtee's name. He confirmed to Greenspan, Tamara Lich's attorney, on Friday, he doesn't plan to adduce any new evidence. Then gets to court yesterday and says, yeah, you know what? I want to examine Tamara Lich again because maybe it'll keep her in jail for another day. She was kept in jail yesterday, and they had the hearing today. The judge set aside the Justice of the Peace's order, and he did it in a good way. Hold on, let me just get this off. Justin is attacking our farmers now. You got to reduce your nitrogen output because it's climate change, global environment. Reduce the fertilizer use. just like that, because it's proven, it's demonstrable, it's matter of factual, and the 30% reduction, it's not like what other people have just started floating globally. Other interests saying, you know, we better start compelling a reduction in fertilizer, as if that's not going to have any, you know, its own problems, and as if it's a foregone conclusion that that's even a significant problem contributor to climate change. Fascism has come to Canada under the mask of liberalism. Literally, dark days are ahead of us who remain here. Anyhow, so that's the update. Now, so the bottom line, the judge set aside the Justice of the Peace's the Justice of the Peace court order, and he didn't have flattering things to say about the Justice of the Peace. There are these secondary and tertiary, what they call, like, is the detention justified? Was there a breach? Is the detention justified? Is there a risk that the individual is going to commit a related crime to the underlying infraction, and would releasing or detaining the individual bring the administration of justice into disrepute? And if you can believe, not just one, but two prior justices of the peace came to the conclusion that releasing Tamara Lich and releasing Pat King would bring the administration of justice into disrepute. Just let that sink in for 30 seconds. Two justices of the peace. Now, they are lesser, not as humans, not in value of human life. They, in terms of training and stature, they are not judges. They adjudicate, but they're not judges. They don't have the powers of a judge. They're not elected in this. They're not appointed in the same way judges are, and they're not as technically, hierarchically, they're not up there with judges. So one can sort of imagine then that they're slightly more political creatures, that they're slightly more administrative creatures, and they are. They're not. They don't have extensive knowledge of the law, sentencing guidelines, whatever. But they get to decide if someone stays in jail or not, based on alleged non-compliance with bail. Two justices of the peace, in Tamara Lich's case, and another in Pat King, came to the conclusion that releasing non-violent accused who are innocent, who are presumed innocent, and I want to get to this because this judge brought up charter values, Section 11, presumption of innocence, right not to be detained, Section 7, I forget what the 7 was. This judge brought up charter rights, ones which the other justice of the peace clearly did not consider. Two justices of the peace in Tamara Lich's case, and one or maybe more in Pat King's case, came to the conclusion that releasing legally innocent people who are merely accused of non-violent mischief-related crimes, to release them would bring the administration of justice into disrepute. Let that sink in. That is ass backwards. I was going to say bass ackwards, but it's actually ass backwards. It is carriage in front of the horse. It is freedom is strength. Ignorance is freedom. Is slavery is freedom. Ignorance is strength. War is peace. That's what it is. To release legally innocent people accused of non-violent mischief-related charges, to release them would bring the administration of justice into disrepute. You have no concept of the administration of justice. You have no concept of justice itself. And the only people who would actually argue that releasing mischief-accused individuals who are technically legal until they've stood trial and been convicted, the only people who would say that releasing them would bring the system into disrepute are people who do not believe in justice and who believe in political retribution and political persecution. Anybody who believes genuinely, sincerely, that non-violent accused individuals, some of whom Tamara Lich has never been accused of a crime in her life, that releasing them would bring the system into disrepute, you don't know what justice is. You are a vengeful or ignorant or malicious individual who is using the bail system for political persecution. And the judge said as much today. So what the judge said today is that, let me get my notes. First, just by the way, there's an absolute publication ban on the certee's name and identity. So everyone out there, don't repeat the name if you were listening today. And there's also a total prohibition on sharing audio, video, screen grabs, any reproduction whatsoever of the hearing without the express authorization of the court, which you're not going to get. So you can't even screen grab. You can't share snippets. You can't share snippets of audio. What you got to do is take notes. The judge basically said, look, he said that the justice of the peace, I think he said overestimated or overstated some of the evidence, took judicial knowledge of things that he's not allowed taking judicial notice of, like the citizens living in terror and the citizens being totally fearful and apprehensive of Tamara being released from jail. It would cause them terror. He said he might have gone a little too far on that of which he took judicial notice in coming to the decision that he came to. He might have also gone a little too far in presuming that Tamara Lich is going to serve a lengthy sentence, because Karimji, who the judge today said was vigorously and energetically pursuing the position of the crown, the judge said that about Karimji. And I've got to tell you, the judge didn't say that as a compliment. The judge said that as a disguised, as a very subtle insult, because Karimji is not there to vigorously and energetically pursue the interests of the crown, in as much as the interests of the crown are not justice. The prosecutor is not there prosecuting for conviction. The prosecutor is supposed to pursue justice. And sometimes that actually means not prosecuting, even though someone could make a far-fetched argument for prosecution. And by the way, the interests of the crown, a very interesting way of phrasing it, if the interests of the crown are to destroy, crush, and make an example of Tamara Lich, that seems to be what the interest of the crown is in this case. And Karimji, like a true soldier of the leader, pursuing that so vigorously, I will say blindly and with wanton disregard for justice, the rule of law, and our Charter of Rights. But the judge said at one point, and I'm sure he did not mean it as a compliment, you're vigorously and energetically pursuing the position of the crown. And I think that was a needle in my humble view. But he said that the justice of the peace went overboard multiple times. On the one hand, in the weight that he gave to some of the evidence, the judicial notice, the judicial knowledge that he just took judicially. It's an indisputed fact that releasing Tamara Lich would instill fear in the Ottawa population, that they would have no faith in the system if a nonviolent first-time accused on mischief were released from jail. And he also said that the justice of the peace read into the terms of the bail that which he might have gone a little overboard in reading into, because the justice of the peace, who ordered that Tamara Lich be jailed because it was flagrant disregard of the terms of the bail release, she was not supposed to interact in any way whatsoever with Tom Marazzo, who she shook hands with at this event, and there was no evidence of any counsel being present, although the judge today said there was some reasonable hearsay conclusions that people could come to as to whether or not counsel was present. And there's some serious problems with the Crown's position that this was a wanton disregard on the merits, but they'll get there. But this justice of the peace came to the conclusion that she was not supposed to have any discourse whatsoever, and it was a flagrant flaunting of the court order, reading out the fact that the bail terms specifically said that she's not to have interaction with any of the individuals in the absence of counsel, which means that she can have interaction directly or indirectly with the named individuals, including Tom Marazzo, in the presence of counsel. And they were at an award put on by Tamara Lich's counsel. So the judge today said, dude, you went overboard on a number of occasions, but perhaps the most egregious was faithfully relying on the Crown's position, as though it were gospel, that Tamara Lich runs a serious risk of a lengthy sentence on mischief charges. And the judge said, and it's another sharp needle, the justice of the peace is not expected to understand the law. He's not expected to have extensive experience with the law or sentencing, nor should he. It's not in their field of expertise, in their domain of practice. And so when the justice of the peace came to the conclusion, taking as gospel Karimji's egregious, energetic, and I'll say malicious prosecution position, that Tamara Lich stands a good chance of going to jail for a long, long time, the judge's like, no, I'm a judge. I know the sentencing guidelines for non-violent mischief. And the one case that the Crown produced, which I didn't read it, so don't expect me to know anything more than what I heard today, was a case involving mischievous destruction of a Hydro-Quebec power grid. Direct destruction of property. So not so much non-violent mischief as in, let's organize a protest. Destruction of property mischief. And even then, I don't know what it was, if it was years. The judge said, I know the sentencing. I've been doing this for decades. A justice of the peace is not supposed to have knowledge of these things, which is why when he went out of his way to say, it's a foregone conclusion, I'm going to keep her in jail now because she's likely to serve a very lengthy sentence, that he went overboard. And even more, but I liked it. He brought up the charter. You know what? Let me bring up the sections of the charter. We're going to go to an article by the CBC. I just don't want to make a mistake. Section 11, Charter of Rights and Freedoms. He said, not only when you're determining whether or not to release an individual, the justice of the peace basically only considered one set of people, the terrified Ottawa residents who he took judicial notice of would be terrified. They would fear for their lives if Tamara Lich were released. They would have no faith in the judicial system, therefore she stays in jail. He said, you know what? A reasonable person would also place a little bit of weight on charter rights, on the presumption of innocence, on the right not to be denied bail or to have unreasonable bail imposed. Section 11. D. Any person charged with an offense has the right to be presumed innocent until proven guilty according to law in a fair and public hearing by an independent and impartial tribunal. Presumed innocent, not presumed guilty. Presumed guilty and presumed to serve a long, lengthy sentence for nonviolent mischief. And then there was another provision. Oh yeah, let's see here. Was it E? Not to be denied reasonable bail without just cause. And the judge basically said that there's no just cause to have denied her bail on any of the primary, secondary, or tertiary grounds. Secondary grounds, it's a nonviolent offense. Releasing her is not going to cause the public to fear. And what was the tertiary ground? Oh, and the tertiary ground, would releasing her cause the public to lose faith in the administration of justice? He said, no, a reasonable person would actually, and I've been saying this from the beginning, would actually think that the system is in disrepute if it continues to jail a nonviolent first-time offender who has the right to reasonable bail and who has the right to be presumed innocent, not guilty, and certainly not presumed to serve a lengthy sentence. What else did the judge say? He flat out said, nothing in this file supports the idea that she's going to serve a lengthy sentence. He said, I'm not limiting any future judge to come to a different conclusion, but on my analysis of the case as it currently stands, there's nothing in here to indicate that she is going to serve a lengthy sentence. And she's already been in jail, by the way, I think for a total of 50 days. They said 50 days today. I'm not sure about that, but we're going to get to the article. Are all Canadian courts star chambers? The judge got it right today, finally. And I think he's getting a little bit of courage from the Alberta Court of Appeal. Courage is contagious, people. Yesterday, Karimji tried to compare Lich with a multiple. Some of the case law that Karimji is pointing out, is bringing up, refer to serious criminals. And by the way, even the serious criminals got out on bail. Here. Let's see this. Are justices of the peace lawyers? I do. Oh, Barnes, you're in the house. Hold on. Let me see if I can get. Sorry, I'm a total idiot. Not share. I'm going to invite. I do not believe justices of the peace need to be lawyers. Barnes, check your email. I'm going to send you this link to pop in. Maybe we can talk Alex Jones news. Let me see. Oh, Barnes link. Sorry, people. Send. Yeah, so I don't believe justices of peace need to be lawyers. In fact, I know administrative judges who were never lawyers, but I'll Google it just to double check at some point. But so the judge sets it all aside. He says the justice of the peace went way overboard, didn't consider what is the applicable law, presumed many things which were, not to be presumed in the first place. Set aside, de novo hearing today, and Karimji energetically and vigorously pursued the de novo, meaning starting from scratch, as though none of the other orders ever existed. Let's hear it anew. And Karimji was trying to argue that Tamara Lich can't be trusted. She cannot be trusted to respect the terms of any bail, any subsequent future bail, and that they should then impose even more onerous terms. And I think they did increase the quantum of her certi. So he's trying to pit society against society. Anyhow, that's it. Okay, let me hear this. I don't think the real Barnes would ask a question, are justices of the peace lawyers? It seems like a question he'd know the answer to. No, under Canadian law. Let's bring up that article again. Convoy organizer Tamara Lich granted bail. And the CBC's like, damn. Judge sets aside lower court's previous decision. Okay. Freedom Convoy organizer Tamara Lich has again been granted bail. Lich faces charges of mischief, obstructing police, counseling to commit mischief, yada, yada, yada. All nonviolent accusations. After she was accused of breaching her bail conditions, Lich was ordered to remain in custody to await trial for her role in the protest that paralyzed downtown Ottawa. She had been ordered not to communicate with the organizers, yada, yada, yada. Okay, then she went to the gala. In court Monday, her lawyer, Greenspan, argued that the two organizers did nothing more than shake hands and pose for a photo together at the gala. She spent 48 days in jail while she waits to answer for non-violent charges, Greenspan added. He added that she may end up spending more time in custody before her trial than she would ultimately have to serve if found guilty. I agree, and I think it's already the case. On Tuesday morning, Justice Andrew Goodman, may his name live on forever, because he finally got it right, and he finally put a little stick in the spokes of this out-of-control government bicycle. He set her detention aside, moving to a bail hearing de novo, essentially a fresh start. Goodman challenged the Crown Monday about whether he has found a case for mischief that's come close to the maximum sentence of 10 years. The answer to this is no, because there's never been an occupation of a city, the capital of Canada, for 3 weeks, Karimji said. If not in a situation such as this, then what other situation? She damaged railways. She took a blowtorch to railways. She took a blowtorch to power grids. No, she didn't. She organized a protest. And by the way, Karimji, and by the way, previous justice of the peace who took judicial notice of things which were factually untrue. One street was blocked, Wellington. The other street's traffic was getting through. There might have been some traffic, but I was there as a fire truck blasted through one of the occupied streets at no less than 70 kilometers an hour. Oh no, she single-handedly brought down buildings. She restarted the credit system a la Fight Club. No, Karimji, but nice, energetic persecution and not pursuit of justice. On Tuesday, Goodman said he found it unlikely, based on the charges, that Lich will spend a long time in prison. He also noted her charges are nonviolent. The new conditions of her bail include another $37,000 bond and tightened rules around communication with the same list of convoy-linked people as last time. It must be crystal clear to you now that the authorities are monitoring your every action, Goodman said to Lich. You know what that means? That means communism. That means fascism. That means totalitarianism. Whatever you want it to mean. The government is watching your every move for nonviolent mischief charges solely so they can make a political example out of you. That's totalitarianism. Fascism, authoritarianism, communism, call it whatever you want. It's not freedom. It's not democracy. It's not constitutional rights under a charter of rights. It's a desecration of them. But finally, a judge who got it right. He said, look, I'm not binding any future judge. Maybe they're going to find something in this case that's going to totally change it. She'll go to jail for 10 years for what she did. Hold the line. Organize a protest. Non-violent. Help economy be. Political persecution. Who does the city of Ottawa land acknowledge? I think I know what you mean by that, but not sure. So a $37,000 bond. It's some of the conditions are more onerous, but the bottom line, I'm still on the metric system, people. I'll always be on the metric system. Yeah, no. They're watching you. And then, by the way, at the end of the hearing, he says, and somebody please take these shackles off of Tamara Lich. And I didn't realize, because I was listening and not watching, she was in shackles the entire time, like she were Hannibal Lecter. I have an issue. I think the judge could have, he could have ordered them off to begin with. I think the reason why he didn't do that is because he did not want to give the impression of being partisan, of being already having his mind made up. I think he wanted to make sure that no one would accuse him of coming in with his decision already made. But I got the impression as of closing arguments yesterday, his mind was made up, which is why he said yesterday, I'm rendering my decision orally today. I won't have a written decision ready, given time constraints, but I'm working on this tonight. I'm going to express myself orally today. Yes, tomorrow as of yesterday. And I don't want anyone holding me to my oral reasons. There will be a written decision. I knew then that he's going to let her out and not have her sit in a cell while he writes up a written decision. And by the way, shackles for real, Elizabeth. I think they were foot shackles and hand shackles. Please chat, let me know. I think it was foot and hand shackles. Karimji implied with one of his questions that he was going to appeal the decision. He said, Your Honor, when is the written decision going to be ready? As if to say, because you need the written decision if you want to appeal a decision. Hey, why not? So it's our taxpayer dollars, Karimji. You get paid regardless. Got to make Justin Trudeau happy. Keep up with the energetic persecution. Appeal the decision. Waste more of our tax dollars. Waste more of Tamara Lich's defense dollars. It's no skin off your back. You're playing poker with taxpayer dollars. So that's it. Let me see if I didn't forget any notes from. So secondary grounds of consideration was public safety. Tertiary grounds was public confidence in the administration of justice. Neither of those thresholds were met. And he said, even if all the conditions are met, you can still let them out of jail, because keeping them in jail is a deprivation of a fundamental charter right. And even if they meet all these criteria where a judge could order them to be detained, the rule is freedom pending a trial by your peers, not imprisonment, especially for nonviolent crimes. And I see Barnes is in the backdrop, so I'm just going to make sure I got through all the notes on this. He said Crown is going to have a problem proving mens rea on the willful breach of the conditions because Tamara Lich didn't think she was breaching the conditions because a judge said she could go to the gala. It's they're watching her every move, and it's pure political persecution. Yeah, he says the fear of the public was not determinate. Section 11 of the Charter doesn't agree that it's going to be a lengthy sentence. Yada, yada, yada. He said Justice Phillips, the other judge who also got it right, that was Justice Phillips who let her go to the gala. He said he says you presume that the public respects reasonable bail and presumption of innocence, because judges understand the law. These justices of the peace, in this case, in this persecution, have proven themselves to be political tools of political persecution. Okay, done and done. So she's out, she's out and about. Didn't get the notification. I gave there was 10 minutes notice for this one. What did I miss? Everything on Tamara Lich. Go back and rewatch it. I'll have to go back and watch it. Okay, fine. And then we got, on a brighter side, her Give, Send, Go raised around $60,000 before they closed it for reaching its goal. Amazing. A little. Okay, I'm just going to pull up some of these. Thank you. Thank you for covering this, Kurt Shetler. I've been coming at this for a while now. A train leaves Lansing moving 50 miles an hour while another leaves Ottawa at 75 kilometers an hour. Which of these trains is using the correct unit of measurement? All right, bringing in the Barnes. Robert, sir, how are you doing?
Good.
So what I was listening to Tamara Lich all day. I wasn't really paying attention to the Jones trial. I know that the judge scolded him for showing up to court with duct tape on his mouth and speaking outside the courthouse within earshot of the jurors. Do you know what happened today?
I don't know about either one of those aspects, but the biggest event that happened in the day was the Jones's defense lawyer reminded the jury that Jones had repeatedly publicly apologized. The judge came back in and struck that from the record and told the jury they cannot consider it. She said it's not relevant for mitigation. Well, let me read to you the Texas law. Mitigating factors, section 73.003. To determine the extent and source of actual damages and to mitigate exemplary damages, the defendant in a libel action may give evidence of the following matters: any public apology, correction, or retraction made and published by the defendant. So the judge just flat out lied about the law to the jury. The Texas law is crystal clear. They put this in the statute just so everybody knew that this was clearly the law, that the law is that if you issue an apology, you get to argue mitigation to the jury. And the judge just said exactly the opposite. She just lied to the jury about the law. That's what a kangaroo court, this Travis County court process has been. If anybody doubts now what I've said previously, that their rulings about default, their rulings about discovery, their rulings about sanctions were not rooted in the law, were just politically motivated hack jobs, there's no better evidence than what she said today. She didn't cite what the law was. She just instructed the jury by the way, you can't consider that. That's struck from the record. His apologies don't matter. Texas law is clear on that. Texas law says she's lying. That's the reality of it.
Robert, so on decisions like that which strike evidence, is there an immediate grounds for appeal?
Unfortunately, the way a lot of people have been asking why hasn't Jones filed appeals, et cetera. The problem in Texas and in most American courts is that you generally cannot file an appeal until there has been a judgment. And then the additional problem is a final judgment, which means a monetary amount. And the second problem in Texas is you're not allowed, you have to pay the judgment, or the judgment can be enforced while the appeal is pending, unless you're able to post a bond for the amount. And I don't know if you heard, 100 million turned out too low. 75 million per plaintiff, 150 million just for this case. They want over $1 billion in damages for their hurt feelings from mean words. It's interesting what the defense predicted is what I thought the evidence would show, which is that there is no evidence they suffered emotional trauma from Alex Jones's statements. In fact, it's not clear they ever even heard Alex Jones's statements. So how could they cause trauma if they didn't hear his statements? And in fact, there's, according to the opening statement of the defense, no evidence of that. I had seen no evidence of it at the time. In fact, if you read the complaint carefully, it was clear they weren't even clearly alleging it in the complaint, that they were saying this could cause this kind of injury, and they have suffered because of other things, but not on this date. They heard Alex Jones's statements, and then they, sought psychiatric treatment and emotional harm, injury, et cetera.
$75 million for here
per person.
And again, this is not this 75 million against the family of the person who pulled the trigger, or anyone remotely responsible. Yes, Alex Jones who at worst, and also at worst, called them crisis actors. At worst, even if you take it at its, he identified them and unequivocally called them crisis actors, setting aside the apologies afterwards. At worst.
And by the way, the undisputed evidence, as presented, as I predicted, as the defense talked about, in 2012 and 2013, for 2 years after Sandy Hook happened, InfoWars never said that it was a hoax, never said that anything about crisis actors or anything like that. In fact, as the defense presented, that only came up later. It only was sporadic. It was only a tiny percentage of their Sandy Hook coverage. It was even a tinier percentage of everything they broadcast. And so and again, I mean, I hope this point gets made. They may be waiting for cross-examination to make it, but to my knowledge, none of these plaintiffs filed an apology request, a retraction request, a correction request, something you would obviously do if someone was getting something wrong about you. I've never heard of somebody suing that never said, hey, by the way, you got it wrong. And so until the eve of suit. So, but what we're seeing is judicial bias that's so strong, so palpable, she's willing to lie about the law and deliberately misinstruct the jury on Texas law.
I mean, I would ordinarily say she's just mistaken and not lying. But at this point, you have to presume a Texas judge knows Texas law. And
it's in plain language. It's not like a dispute about court interpretation. It's right in this. Anybody can look it up. Look up section 73.003 defamation law. Just Google defamation Texas mitigation, and you find it right there.
Hold on. Let's just see. We're going to do it right now, Robert. What's the
73.003? Yeah, just say Texas defamation mitigation.
Under the Defamation Mitigation Act, the plaintiff may maintain an action for defamation only if the plaintiff makes a timely and sufficient statutory request for a correction, clarification, or retraction.
By the way, that didn't happen here, and yet they've allowed this case to go on.
Well, they're going to say it's the emotional, that's the hybrid lawsuit that they filed. Okay, fine. But they're also suing for infliction of emotional distress, which I guess would not be covered.
The defamation case should have been dismissed. The argument was that the intentional infliction of emotional distress claim should also be covered with it. But yeah, the Civil Practice and Remedies Act, that takes you there. Right, and there it is. Just go down. See, you go down to where it says mitigation.
Mitigating factors to determine the extent and source of actual damages and to mitigate exemplary damages. So this is actual, not just exemplary or punitive.
Yep. Exactly, it's both.
The defendant in a libel action, and then they're going to say, well, we don't want the $75 million for the intentional infliction of emotional distress, not libel, whatever.
But she made it specific, by the way, to defamation. That's what she said today. She said defamation law in Texas.
They may give evidence of the following matters if they have been specially pleaded. Is the argument going to be that they haven't been specially pleaded because he's
that's not what she said. And in fact, they clearly had been specially pleaded.
Okay, because I mean the playing devil's advocate, Robert, if he had been foreclosed from defending,
I mean, she could try to argue that she could have said that as a terms of for the purpose of this case, but that wasn't her statement. Her statement was Texas law doesn't allow an apology to be used for mitigation in defamation cases. I want a statement that's patently false.
Everybody should appreciate the dirtiness of this, by the way, because the statute does read, if they have been specially pleaded. Jones was foreclosed from pleading. And so the argument could be made, well, he didn't specially plead any apology because he was foreclosed from pleading, declared guilty in absentia, and therefore he didn't specially plead it. However, had she said that to the jury, then they would have known that he was foreclosed from defending and that it wasn't like a legit on the merits finding of guilt. This is preposterous. It's preposterous.
It's completely. It's just an ongoing joke. And anybody can people that were watching it on our locals board were pointing out that, this judge was clearly a nasty personality. What you're seeing is and this is a lot of judges are authoritarian personalities, both on the left and on the right. She comes from the liberal authoritarian side. And by the way, she's apparently written books that support my hypothesis that she was involved in defending child abusers. Given what she was writing to parents and being a real advocate for breaking up families, it sounded like to me, but from what I heard. But that this is what a liberal authoritarian looks like in court. So to give an example, she starts talking and Jones is just whispering to his lawyer, which, by the way, has always been permitted.
Always at all times.
Yeah, exactly. I mean, because your client needs to be able to communicate to your lawyer as long as you're not disrupting. You can sit there and say, oh, hey, what about this? How about, because that you need that communication so they can effectively advocate. She immediately jumped on him, said, how dare you? No one should be talking when I, the great judge, is hereby talking. This is a power-mad liberal authoritarian. If you want to see how dangerous the court system can get, just watch this judge. Even if you don't care one iota about Alex Jones, watch this judge and you can see how nuts some of the judges are in America, how they're authoritarian, power-mad judges. It's not a coincidence. Judges disproportionately show up committing certain kinds of crimes, folks. It's because they're power-driven, power-riddled, power-obsessed. And then they're just lecturing about no gum and all this other stuff in the courthouse. I mean, she's a power freak. She doesn't belong on the bench.
Hold on. What are the types of crimes that judges typically get involved in? Bribery and
disproportionately child abuse and other forms of sexual deviancy that usually involves that kind of behavior. That's what.
Okay. So I have to ask because I don't know. I mean, that's okay. Interesting. Hold on. Let me just pull this up because she also admonished. I got to stop screen so I can get back to it. She admonished Alex Jones for speaking outside the courtroom. With allegedly,
no gag order. To my knowledge, there is no gag order.
There's no gag order that I know about.
Bankston's been yipping. The plaintiff's lawyer's been yipping to everybody.
Judge admonishes Alex Jones for speaking outside courtroom on first day of Sandy Hook defamation trial. I mean, imagine this: foreclosed from defending, foreclosed from pleading, foreclosed from raising defenses, mitigating factors, and now shut up outside of the courtroom, no less. A Texas judge overseeing the defamation trial that will determine how much money Alex Jones has to pay. Sandy Hook Elementary School parents, yada, yada, yada. Okay. This is poorly drafted, by the way. It took me a good 30 seconds to understand what they're saying. After he said the Sandy Hook shooting was fake, the judge admonished the InfoWars founder Tuesday for speaking outside about the case within earshot of the jury. I'm curious as to how that works, but we're not going to have that again. Judge Maya Guerra Gamble told Jones and his attorneys. During a break in opening arguments, Jones spoke to reporters inside Travis County Courthouse because you're allowed speaking to. There's a media area where you can talk, I presume. Yeah. Ladies and gentlemen, if you want to be bamboozled and lose your First Amendment, go ahead, Jones said. You're having your rights to a trial by jury to decide if you're guilty or innocent stolen from you. This is a kangaroo court. This is a political act. This is a witch hunt. The judge reminded Jones that every participant in the trial is, quote, ordered to be silent out of this courtroom, or if there is any member of the jury in sight. That's a compound. These are two separate things. So she's right. You have to be silent outside of the courtroom?
There's no gag order in place. So that may be a misquote of the court. And what do you mean silence in the courtroom? In other words, that's not really accurate either. You can't be disruptive. Things of that nature. The Chicago 7 trial, you put that right on trial and provoked the judge into doing so many dumb, crazy things that all their cases had to be overturned on appeal. And again, it's where the media is located. So if she's having the media's in the courtroom, I don't know how that would be within earshot of the jury because the jury walks back into a separate room. So
but Robert, this also says ordered to be silent out of this courtroom. That does that. Yeah,
I think that's a misquote.
Okay, no. Either she might have just misspoken, but because the thing is, possible. Alex Jones, if she's admonishing him for speech outside the courtroom, that is what she's talking about.
Well, I mean, if that's the case, then I'm assuming her jury focus was that that not to say anything inside the courtroom, which is again kind of a overly broad application, and then secondly, an attempt to. And then to say, well, you can't say anything that you think the jury might hear. So that's why that's her excuse. I mean, it's clear what she doesn't like is Jones defending himself in the court of public opinion about her, and her pretext is to be able to use that as the excuse to attack him. I don't think he'll make I've said publicly, I don't think he benefits from being there in the courtroom. This is a kangaroo court. It's a show trial. It's a joke of a case. It's an embarrassment to the rule of law in America. I wouldn't partake in it because they'll use any pretext, as they already have throughout the entire judicial proceeding, to just attack him, belittle him, make him pay money, hurt his case, try to lock him up, something crazy and insane. And so I suspect you will not see Alex Jones back in that courtroom.
Yeah, he's apparently medical issues is what people are reporting is the reason for which he's not necessarily going to be there for all of the trial. But I like this. He says, on Tuesday, Jones arrived at the courthouse wearing a piece of silver tape over his mouth with the message, "Save the First," printed on it. He removed it before entering the courtroom. And then
there's nothing wrong with that. That's free speech. The judge doesn't have the right to suppress that. So gag orders are very limited in their ability to be. There's a reason why there's no gag order here. Two reasons. One, the plaintiff's lawyers want to yip, so they don't want any gag order in place. And then she's done nothing about plaintiff's lawyer statements in the case, which including statements that clearly were meant to reach the jury pool right on the eve of trial in Austin Press. But the second aspect is that it's prior restraint. So you have to have special cause to meet that. I've litigated this in many cases on behalf of other lawyers. I don't think any judge has ever successfully imposed a gag order on me in any case I've been involved in. But they try it in other cases. They try to punish them for speech outside the courtroom. And I've usually been able to get those reversed because it's just not constitutionally permissible.
David March, and I think he's right. In fact, I'm fairly certain he is. Justice is of
the
the
peace.
peace.
I just saw that. Yeah. Well, now it's supposed to be a college degree or its equivalent. But yeah, I looked it up when I asked that question. Yeah, they have to have 10 years of good volunteer work, though, Viva. 10 years.
No, it's amazing.
Have you been a good social justice warrior? Then you are now a justice of the peace in Canada.
Robert, Amy Baudo says, I've never seen a judge allow a jury to ask questions of witnesses. Is this normal? I didn't see that.
I don't know if that happened. Very, very, very rare. Most judges do not. A few do. I don't mind it because it, depending on the circumstances, because it can be very revelatory of the jury's mindset. There was a Texas plaintiff's lawyer trying to argue, Attorney Tom, I think he's been on with Nick Ricada occasionally, arguing with me on Twitter about how this is totally normal to ask for $100 million or more. And I was like, only a Texas plaintiff, and in fact, maybe by the Seventh Amendment entitles me to ask that question. It's like only a Texas plaintiff's lawyer can think you have a constitutional right to a jury that will award you $100 million, Mr. Barnes. It's like, no, that doesn't go that way. You're not supposed to be able to pick your verdict by picking your jury. And that was deeply problematic. And that shouldn't have been allowed in the jury selection. But just to give people an idea, in Texas, they need 10 of the 12 jurors. It's not a unanimous requirement. They need 10 of the 12 to agree. And on average, an average Austin jury, 9 of the 12 would be liberal Democrats that voted for Joe Biden. Mm-hmm. So that gives you an idea of the bias that pre-exists here in Austin. And then she helped inflame that further by how she allowed the plaintiff's lawyers to conduct it and how she herself conducted herself during the proceedings. And then continued with it. Now, one odd thing, by the way, the camera they have in the courtroom shows a couple of the jurors, which I've never seen before.
That's
not a big deal.
Well, someone had just asked that because we haven't seen that in any of the other televised trials.
Now, as a whole, I think all of the other trials that we've seen that have been recently in the news, maybe not Rittenhouse, but the rest, I think they were anonymous. No, actually, Rittenhouse too. I think jurors' names were anonymous. I'm not a fan of that because if you can see the jurors if you're there in the courtroom. So the whole point is to extend the courtroom to the world. So I've never agreed with that. Once you decide to sit on a jury, if you can't constitutionally discharge your duty to be an impartial juror because your name will be known, you should not be on that jury. Otherwise, I've not been a fan of anonymous juries. It always goes south or sideways. But the other cases, I think all of them were anonymous juries. Rittenhouse, Chauvin, Depp. So that's why they probably went out of their way not to show them. Now it's a real small courtroom in there. Weirdest courtroom I think I've seen. The lawyers are sitting like this, not facing the jury. They're pointing at the courtroom, and the courtroom feels really small. By the way, it appears the judge allowed a lot of problematic evidence in that didn't relate to emotional distress damages, while precluding a lot of cross-examination that could have gone to certain relevant, pertinent topics. The case is just going to be rigged. The whole jury's trial is going to be rigged. It's rigged to get a preordained outcome of an absurd verdict that's meant to permanently not only silence Alex Jones. I mean, here's what the plaintiff's lawyer said in his opening statement. He said, you're not entitled under the First Amendment to say things that are really important to some people that we think is misinformation. Think about that, folks. This is no longer defamation standard that we've known in America, no longer the constitutional standard we've known in America. This is you say something that you have reason to know somebody be really upset about, they get to sue you into oblivion now, as long as they pick a politically motivated courthouse to do so. That's where we're at. I mean, I used to tell some of my liberal friends, it's like, if this is going to be the new law, I'm going to be suing some folks in some small Republican conservative counties and see if you like it when it's the other way around. And then you had a lot of fake conservatives. So Newsmax was, bashing Jones. Newsmax always been a fake conservative organization, to be honest with you. They pretend to be conservative, but they're only conveniently conservative. They're always on the deep state side when the rubber hits the road. Still Eric Erickson, that guy puts the word con in conservative, always has. And so he was against election challenges, hated Trump. What you'll find is that most of these people were on the wrong side of Trump 2016 in the primaries. We're on the wrong side of lockdowns. We're on the wrong side of mandates. We're on the wrong side of vaccines. We're on the wrong side of election issues. And we're on the wrong side of the Ukraine conflict. That's what they all have in common. Not coincidentally, they're glad to hammer Jones. But what they don't realize is they're cheering a legal precedent that can bankrupt them tomorrow. And that's what they're not waking up to, especially if anybody watches this. I didn't know anybody on our board who watched it. I mean, people that thought, maybe Barnes being over the top. People are like, this is worse than you described. This judge is worse. This whole thing is worse. I mean, $150 million, $100 million turned out to be a low estimate. Somebody go out there and find it. I know of no case in world history where a jury where anybody has been awarded $75 million or more purely for emotional damages, purely for words being spoken. It is unheard of, unprecedented. But it shows how dangerous this case is to freedom in America. Oh, you're on mute, Beaver.
I promised my kid we would go out for dinner sooner than later. But are you going live at 9 o'clock, 9-ish?
Yeah, I'll be live in about an hour, a little less. It's always 9-ish, everybody, New York time. At vivabarneslaw.locals.com. And we'll break it down a little bit more there and answering everybody's questions in the live chat. So just go to vivabarneslaw.locals.com. Live stream Bourbon with Barnes in about an hour.
And tomorrow night, we've got an amazing sidebar, again with Francis Christian, who's the doctor who was he was ultimately fired. He was besmirched by the media because he took an critical position of COVID measures. He's going to be on with his lawyers, and I think it's the JCCF. He's going to be on with his lawyers, 7 o'clock Eastern. So it's going to be 6 o'clock your time, 5 o'clock my time. Tomorrow night, people. So stay tuned. It's going to be fantastic. And now you have the latest on Jones and Tamara Lich. Robert, I'll see you tomorrow. And everyone in the chat, have a good night. Nope.
I'll be live tomorrow, guest hosting Alex Jones's show at Infowars.com. So tune in around noonish, 1-ish Eastern time. I'll be on for a couple hours. The Duran's going to be on with me. George Gammon's going to be on with me. So we'll have some fun discussing some hot topics in a completely uncensored platform, because the last place on earth that really is that fully and wholly, or one of the last places on earth, is Infowars.com.
Awesome. Everyone, enjoy the night. We'll see you all tomorrow. Robert, have a good one. Peace out, peeps.